All right, we're back on record. It's been a bit longer than anticipated. We've got a sidebar. The attorneys have had an opportunity to talk with their clients as well. We've got Ms. Dumont back, and here we are. So we've got all of our same parties and attorneys. Anything to say for the record before we get into closing arguments, counselors?
Judge, I think we might have a stipulation, if I can place the terms of that on the record. Judge, I think we have an agreement that the conservator would reimburse the estate for any expenses that were incurred prior to his temporary appointment, which I believe was on April 7th of 2022. The only exception to that would be any legal fees that were incurred on behalf of conservatorship and the guardian in preparing the petitions for the temporary emergency and ultimately the final appointment as a conservator. Additionally, he is going to attempt to locate and provide copies of receipts for expenses incurred during this time, specifically like airline tickets, hotels. That requirement does not include meals. And the reason it doesn't include meals is we've all agreed that because he reimbursed the state for half of the meal expenses yesterday, apparently, I think that satisfies the meal requirement. So he will provide those receipts. It's my understanding that the court would take final ruling on those objections under advisement pending receipt of the receipts. The court will review them and make a final decision on what, if anything, should be reimbursed to the estate. With those two caveats, I guess I want to place one other thing on the record, Your Honor. Mr. Parks clarified for myself and my client that although there was billings on the attorney fees that were listed after the closing period of this first accounting, they were not added as expenses to this annual account. As I've explained to my client, whether they end up on this, the first accounting that we're here for you on today, or the second accounting, which is going to come in, I think, here in the near future, regardless, those are generally warranted, they're reimbursable expenses. So I think it's kind of a form over substance argument as to which accounting they go on. My client knows that she will check and ascertain when the second accounting comes to make sure they're not hitting both accountings. But as I stated in our supplemental brief, we have no objections at this time to the attorney fees. And with that, I think that is the agreement that we've all reached.
All right. Well, perhaps most importantly, Ms. Parks, is your client on board with this?
Yes, Your Honor.
Very good. To our guardian ad litem and our court-appointed attorney?
Yes, Your Honor, I believe that is what we've agreed on.
Yes, Your Honor. All right. Did you want to take any testimony from your clients?
If I can just walk here my client briefly.
You are. All right. Yes, Ms. Xavier, you remain under oath.
Is that a yes? You understand?
Yes.
Okay. Sally, you understand the terms we just placed on the record?
Yes.
And you're agreeable with those terms?
Yes, but when would the receipts be due?
That's up to the court's discretion.
Okay.
Okay, but you're agreeable with those terms?
Yes.
Okay, and you understand that settles all of our objections?
Yes.
Okay, you have a right for me to continue arguing this case, and the judge is going to make a final decision, but you'd rather settle it with that stipulation. You agree with that?
Yes.
Okay, I have no further questions, Your Honor.
Thank you. I would look for those receipts within the next 30 days, which is what I typically do in order to allow someone to provide receipts. I'll typically give you like a 30-day adjournment for that anyway, if that's, we're getting nods of the confirmation. Yes. Ms. Parks, any questions? Or does any of our other attorneys have questions for Ms. Sally Xavier?
No, Your Honor.
No.
No, Your Honor.
Very good. Ms. Parks, would you like to hear from your client?
Yes, Your Honor.
All right. Mr. Sunbath Xavier, or Sam, you also remain under oath. Do you understand that?
Yes.
Thank you.
Mr. Xavier, do you understand the agreement as stated by Mr. Baker?
Yes, I do.
And do you agree to those terms?
Yes, I do. I know that's the law, but I had to get there somehow to file this temporary petition. I did not have legal counsel, so there's no expense to the estate for that. And I agree to pay what my travel expenses were prior to April 7th.
And you understand that you have 30 days to provide receipts to the court regarding expenses incurred such as hotel fees, airfare after your appointment, correct?
Correct.
I have no further questions, Your Honor.
Any other questions for Mr. Xavier?
No, Your Honor.
Nothing further, Your Honor.
No, Your Honor. Very good, thank you. I do think that those travel expenses, I'm looking forward to reviewing those to determine whether or not they conform with what's expected both locally and at large in our case law with reasonable compensation for our conservators. But I also want to say I appreciate that the funding for those expenditures was in a much better position at that point than it is now. I hear you, Mr. Xavier. And I want to say that I do appreciate that you're not asking for reimbursement for those moving forward, given the circumstances of your mother's care and the seems rather large increase for that care that's happening. So I want to say I do appreciate that, and I'm sure Sally does as well, frankly. So thank you for your services as conservator and for looking out for your mom and making sure that all that's continuing to be available for her. And I will carefully look at any receipts that you provide for me. But I appreciate also your acknowledgement of my obligations to look at those expenses in accordance with what I have to look at under the law and with our cases.
Okay, thank you.
You're welcome. Who would like to prepare the order?
I think the guardian ad litem will judge. I'll prepare.
All right, Mr. Baker, thank you so much.
You're welcome.
Unless there's any questions, that's all for today.
Thank you, Your Honor.